And that will be at the Neville Public Museum in Green Bay. Okay, so getting started here, talking about Medicaid eligibility. Again, I mentioned it's in relation to like long-term care Medicaid that we're really talking about here, but a lot of people have familiarity, or at least some familiarity, with the rules around Medicaid, but sometimes it's not necessarily as accurate as they might think because they read something online or they are looking at a different state's rules. So there can be a lot of different pieces of information out there. So, when we're talking about Medicaid, we're talking about a program that can be used to help someone pay for long-term care if they don't have the money to do so anymore. So Medicaid can be for people who have lower income. It can be for people who can't afford their long-term care, but there are both, income and asset-based limitations for people to qualify for Medicaid. So for a single person, it's pretty straightforward what the single person can keep. You can have your primary residence, but Medicaid can place a lien on that primary residence. We can, so eventually, if you've ever heard of the discussion around like the nursing home took my mom or dad's home, or, we were trying to save the home, but the nursing home took it. It's not so much the nursing home that took the home. It's actually that in order to qualify for Medicaid, they had to allow Medicaid to place a lien on that home, and eventually Medicaid could recover against that home after the individual passed or after it was sold. So Medicaid is what, quote unquote, takes the home, not the nursing home. So this is for a single person. That single person can also keep around $1,500 in life insurance. That's the face value of that life insurance policy. If they have more than that, like a lot of people do, they can look at the cash value. Medicaid can see the cash value of the policy as an asset. So that's something then that they would have to potentially cash out and spend down. The single person can prepay their burial expenses up to about $15,000 for themselves or for loved ones as well. So they can prepay their burial expenses. They will need a list of, from the company that they paid for that expense through, a list of the goods and services to make sure that they didn't, prepay in a way that was going towards like the food for the family or the, other sort of non-essential burial expenses. But it is something that can be prepaid. And excuse me, the last thing that they can have that's not counted against them is one vehicle, and that vehicle has to be of a reasonable value. It has to be something that they're actually could be using for transportation, right? There were some test cases where people had like sports cars that they tried to claim as their exempt vehicle, and that got shut down. So it has to be a vehicle that you could use for like medical appointment transportation. So a standard vehicle for most of us anyway. And then outside of those things that single person can have to qualify for Medicaid, a single individual has to be below about $2,000 in assets. So it's quite a low amount of like their bank accounts, their retirement accounts, the cash value of those life insurance policies that are over that $1,500 face value limit, additional real estate they have. It's pretty restrictive. They have to be below $2,000 in countable assets. So for a lot of people, that involves spending down quite a bit. In terms of their income, the income of the individual must be lower than the cost of care. So if they have enough income to qualify for, or to cover their nursing home or assisted living expenses, let's say my cost of care is about $4,500 a month, which would be low on the low end, just so everyone knows. But I'm making $6,000 a month in income. Well, I would not need Medicaid because my income can cover that expense. So in order to qualify for Medicaid assistance, the person who is applying for that assistance must be below in income the cost of care. Of their income, the single individual can only keep about $45 a month. The rest of that income must go towards the cost of care in order to supplement Medicaid's expenses, essentially. So that $45 a month is called their personal needs allowance. And that number does not go up with inflation. It's been the same for many, many years. So it's just something to be aware of, that if you have needs that are not being covered by Medicaid, or wants that are not being covered by Medicaid, the amount you have to supplement your Medicaid just from income alone, what Medicaid is paying for is only $45 a month in most cases as a single person. So that is obviously not a lot, and people try to look for ways to have more supplemental either assets or income from family or friends in order to help support some additional needs or wants. So Medicaid will cover the necessities. They'll cover the room that you're in at a facility. They'll cover the medical expenses. A lot of times they'll cover even most of the, prescriptions and drugs that are needed if they're not already being covered through like their Medicare supplemental insurance. But if it's something like maybe they want for quality of life, the private room at the facility, or they want to be able to watch cable or have a cell phone or things like that, can be very difficult for that individual to afford that off of that $45 a month personal needs allowance. Now, if we're talking about a married couple, these figures change quite a bit. And what a married couple can keep while one of the spouses is on care depends on a variety of factors, but whether or not both of the spouses are in care is a big factor. If it's just one spouse, which spouse is it is a big factor as well. So if there's a married couple that's looking to have Medicaid start covering the cost of assisted living or skilled nursing for an individual, what they are allowed to keep is much different than that single individual, as I mentioned. So for Medicaid, they differentiate spouses based on who they call the community spouse. That community spouse is the one, if you want to think of it from a general standpoint, is the one at home, right? The one who's not in need of care right now or is not currently receiving care that they need Medicaid assistance for. Then they also look at the other spouse, the one who is in need of that, like nursing home assisted living care, as the institutionalized spouse, the one who is applying for Medicaid benefits, essentially. And based on what types of assets the institutionalized spouse has versus the community spouse has, that can play a role in determining what is it that the community spouse can keep and not have to spend on their spouse's care before they receive Medicaid assistance. So the community spouse is able to keep with no lien on it at all, the primary residence. So the spouse who's living at the home still, in their home, that is, does not have to worry about the nursing home taking the home. We often hear incorrect advice from clients who, like, they've talked to somebody at the facility or they've talked to somebody, a family friend or something like that, where they're being told, well, you're going to have to sell that home in order to pay for care because that care is going to eat through everything. The problem with that advice in this context is if one of those spouses is living at home still, it's not something they have to sell or spend through. It's a protected asset for that community spouse. And by selling it, they could actually be converting it into something that is no longer protected, which is just cash. So it's something that they have to be very careful about when they're getting that kind of advice and making sure that that advice is coming from the correct individuals and not somebody who is not qualified to be giving that advice. In addition to the primary residence, that community spouse can keep that vehicle, the one vehicle, just like that single individual could. They can keep the $1,500 in face value of life insurance before cash value becomes countable. They can prepay their burial expenses again, just like a single individual could, and they can do that for both spouses in this context. And then depending on how they have their retirement accounts divided between the two spouses, the community spouse is able to keep any like IRA, 401k, 457, 403bs, like any of those types of qualified retirement accounts. They are able to keep any of those and not have to spend through those that are in the community spouse's name. So this can be both a very good thing or a very, detrimental thing potentially, depending on who or which of those two spouses has more of those qualified retirement accounts. So sometimes spouses are pretty even on that. And if that's the case, then both spouses are relatively kind of evenly protected, so to speak, from the other spouse's care. But in more traditional marriages, you often see, for example, the husband have almost all of those accounts. And from a statistical standpoint, the husband is also the one who may be more likely, if they're a similar age, more likely to need care first. And the spouse who's in care, their retirement accounts are not exempt. They are counted as an asset. Depending on that breakdown, you could have a much different amount that spouse at home gets to keep, that they don't have to spend on the other spouse's care. Um, so, all of the other things that I have not mentioned, so like bank accounts, regardless how they're titled, if it's just cash bank accounts, non-retirement accounts, investment accounts, mutual funds, things like that, additional real estate, the cash value of high face value life insurance policies, all of the things that are not exempt, Medicaid is going to pool that value together and they're going to add it up in terms of like what that person has. They will then divide that in half and say that the community spouse can keep some amount of that available source of funds. So this is, again, not including the primary residence, not including that community spouses, that healthy spouses retirement accounts, for example, but they can keep some of what they would have to spend on care too. Now that half though, that half that they can keep has to fall within a certain range. $50,000 is the floor. So if you already only had $50,000 as that community spouse, that's what you had between the two of you. In theory, you would keep all of what you had because you're already at the lowest amount. But the ceiling on that half is about $155,000. So if you say somebody comes in with $400,000 of available assets, that community spouse is not keeping a full half. They're keeping only up to that $155,000. So it's something that, how much you can keep of those available funds depends entirely on how much you have in available funds to begin with, up to a certain point. But in the context of somebody who maybe is already at that cap, they have that $400,000, they're keeping the full 155 that I mentioned. That is not counting their retirement accounts or not counting the home. So they could, depending especially on their qualified retirement accounts, be keeping quite a bit more than that 155,000. So it is very dependent though on how those accounts are handled and held. Of income for a married couple, the income of the spouse who's in care, just like that single individual, they can only keep about $45 a month personally. The rest of it has to go towards their cost of care. However, some of their income can be shifted over to the spouse who's at home if that spouse at home has less than about it's a little over $3,000 now per month in income. So if they're under that amount, they can shift over some of the income of the spouse who is in care as a way to still survive and cover expenses. But that can be a huge decrease in what they're used to living off of if, for example, they themselves only have like $1,500 a month in income and the spouse who's in care is bringing in $8,000 a month, right? That's a huge difference in cost or income coming in still. The spouse who's at home, however, let's say they are the one with more of the income than the spouse who's in care. So if they themselves are that person bringing in $8,000 a month versus the person bringing in 1,500, they can actually keep all of the income coming in their name. So depending on which spouse has the higher income, sometimes the spouse who's in care is actually the one who has the lower income. The spouse who's at home is over that $3,000 a month in income, and they get to keep all of the income regardless of the amount. So in theory, not that this is necessarily a reasonable example, but I could be making $10,000 a month, $11,000 a month in retirement, and if my spouse is in care, I would not have to spend my income on their care in order to have them be on Medicaid. They could be on Medicaid while I'm still bringing in that kind of money if I qualify under all the other, metrics, the asset limitations and all of that. So it is entirely dependent on how much you have, what types of assets you have, who has certain assets like retirement accounts, for example, on what that community spouse gets to keep. Now, other than retirement accounts, one thing I'd like to clarify is that it does not matter whose name a certain asset is in. So just because the bank account's in my name, or our vacation home, cabin up north is in my name, and my spouse is in care, that doesn't mean that just because those other things are in my name that they're suddenly not counted as assets. It is the type of asset that matters, whether it's countable or not. And the only thing that matters whose name it's in is the retirement account type assets. So now, if both spouses are in care, these numbers all change again, and you're more treated like two single people at that point, where again, the home could have a lien placed on it. The income that they each get to keep is only about $45 a month. The same restrictions apply to like the life insurance, where they can only keep $1,500 per person in face value before cash value is an asset. They can prepay their burials still and have one vehicle between the two of them. So it's very similar to a single person at that point. Now, how much they get to keep in terms of assets, what they have to spend down to, depends on whether they are in assisted living versus skilled nursing. If you're in assisted living, or both spouses are, they can keep $4,000, $2,000 apiece. If they're both in skilled nursing, they can keep no more than $3,000 between the two of them. So it depends a little bit again, but there's not a huge difference, obviously, between $4,000 and $3,000 when you're talking about what things cost and what you have available. So when we're talking about what it is that you're allowed to keep, a lot of people will get concerned and want to know, well, how do I actually protect some things then? Because some things are somewhat protected initially, but there can be concerns about, well, what if both spouses go into care? That home could be available, their retirement account could be available again. What happens if we want to protect more than that $2,000 for a single person because they're going to need more than that to supplement things? If that's the case, a lot of people look at transitioning assets away from those people before they need care. And a lot of people have heard of the look back period, or what a lot of people are familiar with hearing it called the 5-year rule, for example. And what that means is when somebody applies for Medicaid, the Medicaid caseworker will be able to look back, and you have to report back 5 years from the date of application to say whether or not something was gifted away, whether it was sold for less than fair market value to a family member, like if you sold your home for $1, for example, whether they, transitioned things into an irrevocable trust to make it unavailable for Medicaid availability. So basically, if you did anything to get qualified, to protect things from that qualification, within the 5 years before the date of application, you have to report it. You can't just not report it. We get that question sometimes. You do have to, it's an affirmative duty to report it, otherwise you're committing fraud. You have to tell them about it, and Medicaid will give you a penalty for the amount that was gifted or transitioned away over that 5-year period. Now, what that penalty looks like is not necessarily a cash penalty that you must pay back. It is a time penalty of how long Medicaid will then not help pay for that person's care based on how much they gave away. So, for example, the divisor for that penalty is roughly about $9,500, so $9,500 currently. So if I, over the 5 years before I apply for Medicaid, gave away $95,000, that'd be about 10 months that Medicaid would not cover my care. So think of it as every $9,500 right now that somebody's given away over that 5-year period is another month that Medicaid won't cover their care. So the issue here becomes, if somebody is, in order to be eligible for Medicaid, you have to be below that income for cost of care. You have to be below those asset limitations, right? So you, by definition, don't have the money to pay for your care anymore. If you can't do that, or your loved one can't do that, and the Medicaid won't be paying for it because of that penalty for a certain period of time, who does? Who does pay for those things then? And it can put families in a very difficult position, unfortunately, of having to figure out, do we as a family step in and start paying for these things? If we were gifted money, do we have the money to be able to do this? The money that they gave away. So it can put families in a difficult position of trying to figure out the best way to deal with that penalty. The problem with gifting in particular with Medicaid is that a lot of people do it thinking that there's a certain amount that they can gift without creating a Medicaid penalty. And what people are getting confused with there is that there's a certain amount that the IRS says you can gift to everybody you know without having to file a gift tax return. So it's related to gift taxes, that gifting exemption, but not related to Medicaid's rules. So that amount for the IRS right now is about $18,000 per person per year. So I could give $18,000 to everybody I know, and I wouldn't have to file a gift tax return. The problem, though, is that even if I went over that and I did have to file a gift tax return, all that does is that lowers my estate tax exemption at the end of my life by the amount I went over. Well, right now that estate tax exemption is 13.6, roughly $13.6 million. So even if I'm going over that kind of 18,000 per person per year, unless I have a lot of money, I don't have to worry about that going over that. The problem with people relying on that rule is that, as I mentioned, that's an IRS rule. That is not a rule for Medicaid. And as we're all familiar with, I'm sure, just because one government agency is saying one thing does not mean the other follows those same rules. So even if somebody was following that gift tax amount over those 5 years, and that's how they'd been transitioning money away, that is still potentially a concern for Medicaid because it is a gift for Medicaid purposes. It's not exempt for them to do that. So you don't want to be gifting money away just to try to protect it, thinking that you're somehow within the rules. So you have to be very calculated in how you're doing gifting and talking to an elder law attorney in order to make sure that they can help guide you on that if that's what you're trying to do. So another thing that gets brought up a lot is, okay, well, if that kind of gifting is an issue and I'm trying to protect the home, is it a good idea for me to put the home in my kid's name? I've heard that's a good idea. It's a way to protect it. Is that a concern? Well, first and foremost, that is still subject to that 5-year look back because it's a gift. You know, you gave something away to protect it. But the problem when people put the home in the kid's name is they often trade one liability for a lot of other liabilities in the process. So what do I mean by that? Well, when you put the home in the kids' names, there's 3 major concerns. If I had to, summarize 3 major concerns that we have when somebody's doing that. First and foremost, if you're concerned about loss of control, there's no worse way to lose control over something than to have somebody else just own your property. So for example, this is where some people will hear these horror stories of, well, mom gifted the home over to her son, and that son started charging mom rent or tried to evict mom because she wasn't paying rent or sell the property without her approval, right? And that's from a moral standpoint, an awful thing that happened to that mother. However, from a legal standpoint, if you transition ownership away from yourself and you have no other sort of binding agreements in place to protect yourself, that is a legally valid thing that somebody might be trying to do. The other major concern with gifting, just transitioning the home over to the kids without it being a sale, for example, and by sale, I mean like a true sale, not like here's $100 for the home type sale. When you gift things like real estate or stocks over to another person without them purchasing it for fair market value from you, you are essentially telling the IRS that that home is worth to them whatever you paid for it when you originally bought it or built it, what you have in the home. That's what's called cost basis. And cost basis is how the IRS determines when you sell something like real estate, whether or not you have capital gains that you have to pay tax on. So if I sold my home for more than I bought it for, that's a capital gain, right? And when you gift it to somebody, you transition that over to them at that rate. If you buy property at fair market value, that's your cost basis. So it's better for them to purchase it from a tax standpoint than it is to just gift it over. The concern, though, is that what happens when the kids need to sell the home? What happens even if they wait until after you pass away, if they already own the home, how do you minimize those taxes then? And if you gift property over and then they sell it after you pass away for whatever the fair market value is, they will have to pay 15 to 20% of capital gains tax, depending on their income, on that gain. Unless they are living in the home as their primary residence for 2 of the last 5 years, which is not often the case. So by gifting the home over to the kids, you're often transitioning over that tax liability as well. Well, if you sell your home and it's your primary residence, you don't have to pay capital gains tax on gain as long as that gain is under $250,000 for each, spouse, for example. So if you're single, it's 250. If you're married, you double it. So most of us don't pay tax on the sale of our primary residence. But if that is not the primary residence of the kids anymore, that they don't get that same exception. The better way to transition a home is to actually have inherited it. Because when you pass away, if you own your home when you pass away or it's in your estate, that capital gain essentially gets wiped out initially because they receive an adjustment up to fair market value of that cost basis. So it's a stepped up basis, you may have heard that term. And that is much better tax-wise to inherit it that way because then you can lessen or eliminate those taxes. But the bigger concern with gifting the home to the kids is that whatever happens to them after they own the home happens to your home. And so what I'm talking about there in particular is the liabilities that they have, the things that can happen to them. Those become the liabilities of your home. So if it's your primary residence, for example, and you file for bankruptcy, there's some bankruptcy protection for your home. You don't have to always get evicted from your home just because you're filing for bankruptcy. But if your kids no longer live in the home and they own it and one of them has a bankruptcy, it doesn't matter that you're still living in it. That's a secondary asset for them. They may have that susceptible to their creditors, for example, or their lawsuit liabilities, susceptible to divorce, or if they pass away, it can be their ownership can be passed on according to the terms of their own estate plan, for example. And it can open up a can of worms for a lot of unforeseen circumstances. So when you're talking about like a real world example of this, we met with a family many years ago where they had given the home many years before they needed care. So they weren't at odds with the 5-year rule. They were way past it. But it came time to sell the home because they couldn't afford it anymore. And they had gifted it to their 4 kids. But in the intervening 20 years since they'd initially transitioned it over, 2 of their 4 children passed away. And so 1/4 of the home went down to a son-in-law. This wasn't the issue here. The other 1/4 of the home, when the second child passed away, went to their grandson because the child was a single parent. Well, when they initially did the planning, the grandson was about 5 years old, and 20 years later, he's in his mid-20s, right? What they could not have foreseen is that the grandson would develop a major substance abuse issue. And when the family came to talk to us, it was because they wanted to make sure that when they sold the home, not that the grandson wouldn't benefit from the money, but that he wouldn't be able to access it himself because they were concerned of how he would use it. The problem with that, the way they'd gifted it over is in order for that grandson to not have a right to that money, he would have to willingly give it up, which was not going to happen in this case. So you don't want to protect your home, excuse me, from Medicaid expenses just to open it up to a bunch of other liabilities and unforeseen things. So, excuse me, if you have a desire to protect the home, there's a much better way to do that, and that's using an irrevocable trust to do it. It's still subject to the 5 years. However, you maintain the right to reside in the home. If your kids are even the trustees, they can't evict you or charge you rent, right? They can't. Their liabilities are not the liabilities of that trust. And it's still a part of your estate, so it wipes out the capital gains issue when you pass away. So you still have to trust the people. You still really want to make sure that you trust who you're putting in charge, but it's a much safer way to do it. But you still have to be concerned about looking ahead to 5 years. I'm out of time here, so I just want to leave you with one last thing, and that's what if somebody doesn't have 5 years to do this, right? What if they're already in care? How do you protect things then? What's very important to be aware of is that there's still planning that can potentially be done for somebody, but What they need is very good authorities in their financial power of attorney in particular to make sure that their financial power of attorney agent has the authority to do effective Medicaid planning for them. And those could be things like, can that person make gifts? Can they establish an irrevocable trust? What standards of gifting do they have to use? And so if you have concerns about not making the 5 years, know that you're not necessarily out of luck, but it's very dependent on the power of attorney that you have, that document you have in place. And know that they're not all created the same. They depend very heavily on what is in the document, what's written in the document. So I apologize. There's a lot more I could talk about here, but we are out of time. So just a quick reminder that you'll get a feedback form from us that if anything I've talked about today makes you go, oh man, I really should talk to one of the attorneys at Hooper Law Office so that I can see what I could do for myself or my loved one when it comes to Medicaid planning or planning for long-term care expenses. Please fill out that feedback form and let us know that you'd like us to reach out. That is a complimentary initial consultation. We do schedule it for about 2 hours, just to give us plenty of time to go through the questions and the information. And then if you're interested in hearing more about Medicaid planning or how trusts work or how wills work, we are having our in-person public seminar next Wednesday, 2 p.m. and a 6 p.m. session at the Green Bay Neville Public Museum. If you'd like to sign up for that, you can do so at estateplanninglive.com. And we just ask if you can do that because seating can be limited. So otherwise, if I don't see any other questions, I hope to see you all next week at the in-person public seminar. And thank you for taking the time to listen